This is not breaking news. This is not a scandal. This is not about one person. This is about something quieter and more dangerous, because the system you think you live under, one set of rules, one set of rights, can be rewritten without a vote. Not by changing the law, by changing what the law is allowed to stop. And when that changes, everything changes downstream. Not eventually, fast. If you've ever assumed the country is held together by a single constitutional floor beneath your feet, you may want to reconsider that assumption right now. And if you want to track where this goes, subscribe, because the next phase isn't theoretical, it's operational. We are entering a world where the same rule can exist and not exist at the same time. And the only difference is where you're standing. And once you see the mechanism, you can't unsee it. What truly controls the system now is not a law on the books. It's the shape of the remedy. For 20 years, a single judge could press pause on a state law everywhere, even when only a few people were actually in the case. One courtroom could reach across 50 states. That wasn't just power. It was speed. It was uniformity by force. Now, the court has pulled that lever out of the wall. And when you remove that lever, you don't remove conflict. You multiply it. You take one national fight and turn it into dozens of smaller fights, each one expensive, slow, and geographically trapped. That's the pivot. Not ideology, not personality, procedure. Because if relief only protects the people brave enough to sue, then the Constitution stops acting like a floor. It starts acting like a fence line. And once rights become boundary dependent, the country doesn't break in half. It breaks into pieces. And the next piece to move is the one nobody can afford to improvise: enforcement. For a long time, Americans got used to a strange magic trick. Before, when a government action was challenged, you could reasonably expect one answer to spread. One rule, one stop sign, one national pause while courts figured it out. Now, the normal is shifting towards something older and more dangerous: a slow-motion return to local reality. A world where the same question gets 50 different answers, not because the Constitution changed, but because the reach of the court did. And that kind of change is hard to notice at first, because it arrives as procedure, paperwork, technicalities, the kind of thing you skip. But slow change is how systems fail without alarms. Because when the legal pause button shrinks, power doesn't disappear, it relocates. It flows back into state lines, into district lines, into the places where most people don't have lawyers and don't have time. So the shift isn't loud. It's silent. It's administrative. It's normalized. And then one morning you learn the rule you relied on was never a rule. It was a temporary ceiling, and now it's gone. Which brings us to the first shock, already in motion. Here's the first jolt, and it's not theoretical. Within hours of this shift, state legal teams started moving like they'd been waiting for a signal. Emergency filings, rapid citations, new demands in old cases, a speed run of the courts. That reaction tells you something. Not about who's right, about what this tool was worth. Because the old system let one lawsuit create nationwide gravity. One favorable judge, one sweeping order, a freeze that reached far beyond the people actually standing in the courtroom. Now that shortcut collapses. And when the shortcut collapses, the same conflict doesn't end, it spreads. It pops up in multiple districts at once, different judges, different rules, different timelines. So you don't get one injunction. You get 15, or 20, or none. And the gap between those outcomes isn't justice, it's geography and money. Major institutions are already reacting as if enforcement can restart in places that assumed they were protected. And that's the cliff, when a blocked policy becomes live. Again, not everywhere, just somewhere. And then the country finds out in real time what patchwork feels like. This is where the mechanism shows itself cleanly. The system worked like this. If you wanted maximum impact with minimum cost, you didn't fight everywhere. You fought one place. You filed where you expected a friendly judge. And if you got a nationwide injunction, you didn't just win a case, you changed the operating conditions of the entire country overnight. That's why so many of these sweeping orders came from a tiny number of districts. That isn't a conspiracy. It's a strategy. It's forum shopping, efficient, predictable, devastating. Now remove nationwide reach. Now the incentive flips. If you want broad protection, you don't file once. You file again and again in different circuits, under different precedent, with different odds, with different appeals, which means the people who benefit are the ones who can afford duplication. And the people who absorb the damage are the ones who can't, because litigation doesn't just cost money, it costs time. And time is the thing that enforcement eats alive. So the new machine is not states win or feds win. The new machine is fragmentation wins. And once fragmentation becomes the default, the next question is brutal and immediate. Which rules become real first? Because someone decides to enforce them first. Now the second mini crisis hits, and it hits faster because enforcement doesn't wait for legal theory. There are areas where the system is currently held together by injunctions, multiple ones. Immigration, firearm rules, healthcare access, environmental enforcement. Each category already living under layered court orders. Under this new reality, those orders don't automatically cover everyone. They can shrink. They can splinter. They can protect the named plaintiffs and leave everyone else exposed. So you get a map where policy is on in one state and off in another. Or worse, on in most counties, off in a few. The same statute, the same country, different reality. And when that happens, every institution built for uniform rules starts to misfire. Agencies, hospitals, employers, local governments, people trying to comply with something that no longer has one definition. The pace speeds up because the incentives speed up. Officials who want enforcement will move immediately. Officials who fear harm will scramble for new lawsuits. And the courts will be flooded with copy and paste emergencies. That's not stability. That's churn. And churn is how you get to the cliff line. If the rule changes when you cross a county line, what exactly is the nation enforcing? This is the part where it stops being about abstract rights and starts being about you, because you don't live in the law. You live in a place, you live in a zip code with a courthouse attached to it. You live under a set of rules that can now hinge on whether someone with time and money sued in the right district early enough with the right plaintiffs. If the injunction protects only the people named in the case, then protection becomes a membership card. And membership depends on access to lawyers, access to coordination, access to resources that most people never have. So what changes isn't only the law, it's your risk. It's waking up to find out that the policy you thought was paused is active again where you are. Not because a legislature met, not because an election happened, but because the remedy didn't reach you. If this feels like the country turning into a maze, that's because it is. So yes, subscribe. Stay with me. Because the next step isn't just domestic confusion, it's spillover. It's the moment fragmentation stops being a legal headache and becomes a systemic export. And once that starts, it doesn't reverse cleanly. Now widen the lens, because patchwork doesn't stay local. When a major country stops enforcing its own rules uniformly, it sends a signal outward. The system is predictable in name only. And predictability is the currency that markets, treaties, and cross-border planning are built on. Think about what a fragmented enforcement map does to anything that touches multiple jurisdictions. Supply chains, finance, digital services, health systems, environmental standards that don't respect state lines. The spillover is structural. The estimate in your material is blunt. Multi-state compliance costs can explode. Not because businesses suddenly became fragile, but because the rules they rely on can no longer be treated as one standard. And once large institutions start operating as if America is 50 regulatory zones instead of one, they begin redesigning around that assumption. They invest in segmentation, they harden boundaries, they price in uncertainty. That matters internationally because foreign partners don't negotiate with counties. They negotiate with a country. And a country that can't guarantee uniform enforcement starts looking less like a single actor and more like a contested space. This is how a procedural shift becomes a global condition, not by announcing itself, but by forcing everyone to adapt. And the next arena where adaptation is most dangerous is the one that cannot tolerate improvisation: elections. There is one machine in America that breaks catastrophically when the rules are unclear. And it is the voting system, because elections are not a debate. They are logistics, ballots, deadlines, training, equipment, chains of custody. You cannot rewrite the operating manual in late September and expect democracy to run on vibes. Your material points to active injunctions in election disputes, rules about ID, mail ballots, early voting, voter roll maintenance. Under a world of narrow relief, those injunctions can become geographically thin, county thin, plaintiff thin. So imagine the operational nightmare: the same state law enforced in most of a state, blocked in a slice of it because of where the plaintiffs live. That is not a policy disagreement. That is a recipe for contested outcomes. And notice the twist. Both parties have relied on this weapon. Both sides used nationwide injunctions as a fast way to stop rules they feared. That tool is now fading, so the incentive becomes volume. Multiple suits, multiple forums, multiple emergency appeals. And the closer you get to Election Day, the more every side will claim urgency. The courts will be asked to decide at speed with incomplete guidance, which is how you get the most dangerous kind of uncertainty. Not who won, but what were the rules? And once people stop agreeing on the rules, you can't patch that with a recount. Now we reach the future. And it doesn't arrive as one outcome. It arrives as three competing paths. Path one is adjustment. The system adapts. Plaintiffs reorganize. States learn the new boundaries. Congress, under pressure, creates clearer standards so the rules don't fracture into local contradictions. It's messy, but it stabilizes. Path two is erosion. The patchwork becomes normal. Rights and regulations quietly become conditional, enforced here, suspended there. Litigation becomes a rich person's infrastructure. Institutions stop pretending the country is uniform and start building around permanent inconsistency. The Constitution stays on paper, but its reach thins in practice. Path three is rupture. The chaos concentrates in a moment that can't tolerate ambiguity: an election, a public health emergency, a major enforcement swing. Courts issue conflicting orders. Officials choose which to follow. People experience the state as arbitrary. And legitimacy slowly, then suddenly stops being assumed. Here's the problem. These paths can overlap. A country can adjust in one arena while eroding in another and then hit rupture at the worst possible time. And we're not at judgment yet. Not until we look at the final piece hiding in plain sight. Who is steering the speed of all of this? There's a reason this story feels like it's moving too fast. Because the danger isn't only fragmentation. It's fragmentation on an emergency timeline. Your material flags a pattern: the court using emergency orders more often, stepping in more aggressively, expecting immediate compliance without the slow stabilizers, full briefing, full argument, detailed guidance. That changes how the entire judiciary behaves. Lower courts start guessing, states start racing, agencies start preparing for rules to turn on and off with minimal notice. Everyone plans for whiplash. And that's the unresolved warning I want to leave you with. A nation can survive disagreement. It can even survive polarization. What it cannot survive for long is a system where the rules of governance become both fragmented and fast, where rights feel like coordinates, where enforcement feels like weather, and where the remedy is narrower than the harm. Because once people learn to treat the Constitution as something that applies somewhere, not everywhere, they stop trusting it as the basic guarantee. And when that trust breaks, it doesn't break politely. So if you're still watching, don't look away now, subscribe, stay with me. Because the next video has to go deeper into what happens when a patchwork system meets the next shock, economic, political, or electoral. The warning isn't that this ends. The warning is that this becomes normal.